What about the new solutions? I heard about the online, that everyone is trying to use WhatsApp or Zoom or something like this, some technical details, technical instruments, maybe something else. Aloysius, can you tell us some words about this?
So how I have read the situation, and I need to explain that to set the context for the new solutions. I think what we already can guess from the medical experts is that this pandemic is not going to go away quickly. You are looking at something between 6 to 12 months, and many of the governments in Asia especially, we've tried to keep the economies, the livelihoods unaffected with a lot of banking assistance, a lot of injection of funds, but the injection of funds is not going to be continuous. So businesses will start to fail, and a lot of the international contracts will start to fail. As I have meditated on this issue, sometimes I think like what John had mentioned, it's just strange how timing works, you know, and that the Singapore Convention was signed last year and it's going to be ratified this year. And I think it happens for a reason. I think the world needs mediation at this unique time, and the demand for mediation as a cheaper and faster and more practical process is going to grow. But because of the international travel restrictions, the demand is particularly going to be for online mediation. So for myself and my company, for my colleagues, I have been extremely rigorously drilling my colleagues in online mediation. We've been building up our prep, our tech teams. We've been training. We've been doing dry runs of mediations when we don't have cases. And the important thing that we have gradually discovered is familiarity with the video conferencing platform is key. It is also key to recognize that online mediation, as has been mentioned, it's not just about the video conference. It's about how do you manage your emails, your WhatsApp, so that in the event that the video conference fails, there is a ready contingency. And how do you manage Zoom fatigue? We have done a lot of preparation work. We have also revised our mediation rules, our mediation protocol, so that we can prepare for the reality of fatigue, for the reality of how difficult it is to read and manage emotions. And those are all the many things which we've had to rethink and redo. And one of the last things that I'm asking the team to relook at is that in Singapore, we have been very used to facilitative models of mediation. But because of the Zoom fatigue and because of the severe disruptions and how we are so time pressed, it's hard to do a Zoom for 12 hours. People are looking to a more evaluative, a more directive mediation process, so that there is a faster outcome. It is still evaluative, but at some point of time, people are looking for more direction to get a more efficient process. So again, all of these things have been considered and are being introduced to meet client needs in Singapore. Yeah.
Thank you. It's very interesting. Jane Player, maybe you can tell us about some words about England.
Yes, I think we are going to have to think much more flexibly and creatively. And I really echo the words that Jane and Andrew had spoken about in terms of the way that things are moving. I also think that one really good thing, and maybe I've taken the Lucozade that Jane's drunk in terms of positivity, but I do think that lockdown has really helped us mediators emphasize to parties coming to mediation the vital importance of preparation. And maybe because you're doing online platform mediations and you're needing to get people comfortable with the ability to put them into virtual private rooms, what I've found is that you're having a lot more time with the parties and their lawyers before the mediation day. And that has to be a good thing, because they're really now, when you start the mediation day, it's not last minute. You've really thought through some of the issues that might be arising. You've thought through who should be there. Maybe someone who hasn't been mentioned can be brought in to, and you're really working in a much better way. The other thing that I've noticed is that I offer people to have half an hour's practice together before the mediation day, so they can get comfortable with the waiting room, coming into the main session. If they don't want to look at the other side straight away, I can bring them in sequentially. Get them used to the process, not talking about the content, but the process of what's going to be discussed. And I often persuade or encourage people to do that all together. And it has an added benefit of being used to seeing the other side on screen. So it's not a shock when you do it. Just like in a real life mediation, it can be a bit of a trauma for the parties to be face to face across a table in a plenary session when they may not have seen each other for maybe 2 years, because, as Andrew says, they've handed over the dispute to the lawyers have locked horns, they've issued the pleadings, they've polarized the position by pleading it at its extremes, both the claim and the defense, and they're really not in a good place. Maybe the lawyers have fallen out as well. And then you agree you have a mediation. Often in the UK, people come a little bit reluctantly, knowing that there are consequences for not agreeing. So you have the scenario where in a Zoom mediation, you can actually break down a little bit of what am I going to expect? What do they look like now? Have I got a feeling of what's it going to be like to expressing how I feel about this dispute online? So the preparation is everything. It always is in any mediation, but I think the positive point coming out of the lockdown and the increased use of online mediation is that people are taking that much, much more seriously. I'm getting papers earlier, and I think that these new solutions that we're using for the online mediation could have a knock-on effect on mediations for the future in any event. And there's a little bit, I think, of us mediators being a little bit more thinking out of the box, not seeing it as one size fits all, as Jane says, thinking about really designing a process each time with the lawyers, so bringing them into the teamwork here that suits the particular dispute that you're facing. So it might not be plenary first, it might be private sessions. I'm doing a mediation next week with Italian, French, and Dutch participants. They want me to go to Milan to do it next week. We talked about doing it online, but it's not going to be a one-day mediation. I've got to do quite a bit of talking because they're all, it's a boardroom dispute. I've got to do quite a bit of talking beforehand with all the parties to get them into the right frame of mind to recognise that compromise will be required to reach a settlement. But it's great to be able to design a process that fits. And the lawyers call me, explain the problem, and between us, we've designed something that will fit it. So that's very much what I would hope to see, and I think it also encourages the lawyers to keep control, because one other observation I might make is that online mediation has got a difficulty for lawyers, because in a real life mediation, you're sitting next to your client, and if they say too much or they start to speak and you as a lawyer would rather they didn't, you can give them a kick under the table and hope that they'll stop. In a Zoom mediation, an online mediation, you don't have that facility. You're all in different pods. So it's much, much more difficult to feel in control of your client, which I know lawyers might like to do. So again, the preparation time, the time when you're working with them on Zoom, inevitably at the moment, is a time also to give the lawyers comfort that they still can control their clients, that they can explain to their clients that perhaps if they want to say something, they might want to text or email each other first, that they can prep really well to say, we're going to do a plenary and we're going to share it, and the lawyers are going to set out what the legal position is and why they think they're going to win, and then we're going to ask the principal to say something around the commercial effect, the commercial impact that this dispute has had, and why they are willing to compromise today in a mediation for the purposes of getting rid of the dispute. Very useful impact statements, but the preparation of it's even more important to keep both the clients and the lawyers comfortable with this platform that we're now working with.
So maybe we can just ask the Zoom to make some special button called kick for the lawyer or something like this. Okay, thank you, Jane. So let's hear something about Switzerland. Gabor, can you tell us some words about Switzerland?
Well, Switzerland is a very different market because it has a very efficient court system with free conciliation that is embedded into the process. So because also since 2008, mediation has become part of the procedures, and it's even part of the constitution of the Canton of Geneva. There's a very strange understanding of what mediation should or should not be. And what we're struggling with is to get people to understand what the difference is between conciliation and mediation. And that applies also to the Singapore Convention, where both terms are used indifferently. In Switzerland, you cannot do that because they have specific meanings. And there are a lot of efforts being deployed in different areas to get people, the judicial system, to recognize that there is a difference between the two processes, and even provide some trainings to judges and lawyers in order for them to be able to differentiate between the two processes and be able to recommend mediation when conciliation is failed. Conciliation is a mandatory process. You get parties into a room, they sit down in front of a judge who might be deciding on the case at a later stage, and they talk to each other maybe for 10, 15 minutes. They have a long list of cases they have to go through during a morning or during a day, and they don't have time to get into it. So in order for mediation to develop, we have been suggesting that we provide more thorough information to all parties involved, judges, lawyers, and also the plaintiffs or the parties who are involved in a conflict, so they understand better what mediation can do for them. So there are processes that have started to go in that direction, and once we know more how those trainings will take place, we will be able to react and offer something more. I'd like to say just a few words about what I find is really missing from online mediations, as opposed to mediations that take place with everybody sitting together. The element of the mediator is a very important one, and much like in cooking, you have elements that bring a sauce together. That's what the mediator does. Sometimes the binding agent can leave an aftertaste. The mediator, if he doesn't, depending on his behavior during a mediation, he can leave an aftertaste to all parties involved. And also, if the quality of the online mediation process, because you have that human element missing of the people being together in a room, that binding element that the mediator can provide might be missing, and the quality of the agreement that you are able to come to might not be as long lasting as the one that you can get to when everybody is together in a room. Well, this is what I wanted to contribute with.
Jane Gunn, maybe you can add some words about new solutions.
I don't think I've got anything specific to add about new solutions, to be honest. I think much has been covered, really. I just think there are a lot of new ways that we will see things, different ways that we will work with our clients, and different ways that they will begin to give us some ideas about how we can better use the process. And I think we have got to look to our clients to see what their experience is, and learn from our clients as to what they're appreciating, what they're finding difficult, and what we can come up with to help their experience to be better. I really love the idea of Jane's players' design of the process and taking the parties through the practice Zoom call and designing, and that's very much my approach, is to design the whole process with the client. So I think that's definitely the way forward, to be flexible now, I think, and to offer the different alternatives in many different ways, but to be flexible and creative, and to see what really works for our clients, and what they are enjoying and what they're finding difficult, I think, is the thing, and work with that and learn from that. So I do think we as mediators have got a lot to learn, as always. We never stop learning, but we should keep learning about how to use technology alongside all our other skills, and make this a really positive experience for us as well as our clients, and just be as creative as we can with it.
Thank you, Jane. You're always about positive experience, positive side. Thank you so much.